Hello, everyone, and welcome to a new session with Rights and Responsibilities Awareness Initiative. Today, we are super lucky to have Christin Lee, an immigration lawyer, someone who came to Canada as an immigrant, someone who knows what the immigration process is. And she is here today to talk about the refugee claim process in Canada. Christine, thank you so much for joining us today.
Hello, everyone. My name is Kristen, and today I will be giving you a presentation on the refugee claim process. So, like Hetam said, I came here when I was 12 years old. When I was 12 years old, and we settled in London, Ontario. That's where my office is located. My presentation today will be split into 8 sections. Into 8 sections. First, I will be talking about the definition of a refugee under the Canadian law. And then I will be talking about definition of a refugee. And then second, I will talk about who is allowed to make a claim in Canada, claim eligibility. The third is for people who enter from the USA. So I will be talking about the agreement we have with the United States. It's called a Safe Third Country Agreement. Number 4, I will be talking about the refugee claim process. Number 5, I will be talking about what will happen after you receive positive refugee determination. And number 6, what would happen if you receive a negative decision. Number 7, I will be talking about federal court appeal if you received a negative determination. And number 8, I will talk about another option that failed refugee claimants would have, being the humanitarian and compassionate application.
Thank you, Christine. But before you start, if I may just remind our beautiful audience that if you are watching us through any social media platforms, please feel free to type your question into comments or chat. I'll ask them to the presenters. And if you are joining us here on Zoom, please just feel free to raise your hand when we are allowing the questions so you can ask your question. Thank you so much.
So number 1, as to the question of who is a refugee, there are actually 2 definitions under the Canadian law. First, the most common one is convention refugee. What it means is that you face persecution because of your race, religion, political opinion, nationality, or because you belong to a social group. You may ask what does belonging to a social group mean? So it can mean that under the Canadian law, woman is considered a particular social group. Also, victims of domestic abuse is considered particular social group. Also, people who have shown resistance towards illegal armed groups, we try to frame them as belonging to a particular social group. And of course, belonging to a particular sexual orientation. Another definition we have is person or persons in need of protection. These are people who face danger of torture, risk to life, or risk of cruel and unusual treatment or punishment. So you must belong to a particular segment of the population who does not face a general danger applicable to the public. So, for example, just saying that I come from a very dangerous country, that in itself is not good enough. We need to show that you are particularly in need of protection in comparison to the general public. because of your situation, because you belong to a certain segment of group. As to the claim eligibility, most people are eligible to apply for a refugee claim. So I will be, once they arrive in Canada. So I will be explaining this definition by way of who is not eligible. That is if you are recognized as a convention refugee by another country that you can return to. The keyword here is that you can return to. You may have gotten a refugee status in another country, but you cannot return to that country for a certain reason. So if that's the case, you do need to talk to your counsel to see whether you're likely to be eligible. There's or if you are subject to a removal order, or if you committed if you're part of a criminal activity or human rights or committed human rights violations, or if you have made a previous refugee claim in Canada. And if you came through the USA, but you did not qualify for exemptions. So the last point leads me to my next point. Who is allowed to come to Canada from the USA and make a refugee claim? So United States and Canada, we have a bilateral agreement. Basically because Canada and United States told each other our refugee claim is significantly similar. So whoever sets foot in your country should make a refugee claim in your country. So, but then in particular set of circumstances, Canada will allow you to come from the United States and make a refugee claim. Who are those people that are allowed to do that? So there are a number of very narrow exemptions, but many of you qualified, or you may have a family member who will qualify for a family member exemption. That is the most popular exemption that may be applicable to your situation. Basically, it says that you have a family member, if you have a family member in Canada, you can come to Canada and make a refugee claim, although you arrive in the United States first. So that being, if that family member is a Canadian citizen, permanent resident of Canada, protected person under the Canadian law, has made a claim for a refugee status that has been referred to the IRB. They have a removal order stayed on humanitarian and compassionate grounds, or if they hold a valid temporary residence status. So you may ask, who is a family member? Can my great uncle qualify? Can my great grandmother qualify? Can my third cousin qualify? So safe third country exemption narrowly defines family member as a spouse, legal guardian, child, father or mother, sister or brother, grandfather or grandmother, grandchild, uncle or aunt, nephew or niece, common law partner, or same-sex spouse. Refugee claim process itself, I've made it into a chart. So when you decide to make a refugee claim, you can either make it at the border or once you arrive inside Canada. So this process usually typically takes 2 to 4 weeks to go through intake forms, to fill out the refugee portal, to carry out client interview. And we have to fill out this form called the basis of claim form. It's also considered BOC or BOC, where you lay out the basis of your refugee claim. This claim, along with the portal information, is extremely important because this is the first outlook at your case. So basis of claim needs to be sufficiently detailed, must be consistent with the information you set out at in the refugee portal. It's the first thing that the member will see from the outlook the member will have on your case. So we want to make a good presentation of your claim. Once the refugee claim has been submitted, the immigration will ask you to come and do biometrics and medical examination. Biometrics is basically fingerprinting, and this goes to check your criminal record in Canada or outside Canada. So if you have any type of criminal charge or conviction, it is strongly recommended that you tell your counsel, so that it can be taken care of, it can be explained, and your counsel can advise you on whether you're likely to be eligible. Medical examination. Sometimes medical examinations is a rude surprise to some people. What's important to remember is that medical ineligibility does not apply for refugee claimants. So regardless of the result, you should be able to carry out your refugee claim process. And then you'll be asked to come in for an eligibility interview with the Border Services. It's called, with Canadian Border Services Agency, we call it CBSA, or we call it the Border Services. Basically, you're going to go in there and you're going to give away your passport. When you give away your passport, what it actually means is that you are renouncing your right to travel outside Canada until the refugee claim process is over. And you go there with your passport photos, and there will be an eligibility interview where they ask you details about your claim. What's important to remember is that this interview is not a refugee determination hearing. It's simply to see whether you're eligible to apply for a refugee claim. So we usually advise clients to keep it simple, to not bring in any evidence. On this day, you are likely to receive a refugee protection claimant document, also called brown paper. We strongly recommend our clients to learn English with it. And then after that, your work permit is processed. It's important to remember that there's no governmental processing time. Like, the immigration is not required to make a decision in certain period of time. So they can take technically as long as they want. From our experience at the moment, we're seeing about 6 months for the processing of the work permit. Sometimes it is much faster. We strongly recommend our clients to work diligently with the work permit. And then you will be waiting for a hearing. I am seeing around 1 year for a hearing date, but depending on the complexity of your case and depending on the country you come from, it can be much shorter, it can be much longer. There's no really, sometimes even if you do come from the same country, complexity of the case is even similar. There's really no predictability on your on when your hearing will be scheduled. While you wait for a hearing, we ask our clients to collect evidence. Our office, we give them a list of evidence to be gathered. And then once hearing date is scheduled, we work on compiling evidence in the format that the immigration would like, and we submit them on your behalf. After that, we meet our clients for a hearing preparation. So during this session, we go over the format of the hearing, also about what kind of questions are to be asked, how you should present your case. We also remind clients of their weaknesses of the case, what are likely to be issues at the hearing. And then there's a hearing at Refugee Protection Division. So hearing is where you show up and you testify, and the lawyer argues on your behalf. at the hearing, not right now, most hearings are virtual. So everyone joins online. There are usually 4 parties. There's the claimant, meaning the client, and the lawyer, counsel representing the claimant, and the interpreter, and the member. The member is a decision maker. It's a term used at the administrative tribunal at Immigration and Refugee Board for a decision maker. As to the interpreter, if you speak English or French, you can waive your right for interpretation. And so in that case, there will be only 3 parties, and the hearing will probably proceed a lot faster. As to the hearing procedure, in the beginning, there is a check-in with a registry officer, and the member will join the hearing. The member will discuss with counsel about submitted evidence, and then the member will ask the claimant to swear an oath to tell the truth during their testimony. And then the member will outline issues of this particular case, and the member will start questioning the claimants. After the questioning is done, the counsel will also get an opportunity to question the claimants. After that, the member may have a follow-up questions. And in the end, counsel gets to make their final case. It can be either oral or written. After that, the member makes a decision. It will be either by way of oral decision or a written decision. So oral decisions are issued on the day of the hearing. And so they will say your claim is accepted, you're a conventional refugee or a person in need of protection, and they will read out their reasons. However, the written decision, which will actually grant you the refugee status, it will follow later on. It's going to be a transcript of what the member said that day. More often, what the member does is they like to reserve their decision, and they like to think about it, and they communicate their decision by way of written decision. So you might ask what would happen once positive determination has been made. In that case, you can apply for permanent residence and also apply for a travel document. With a travel document, you can travel to any country other than your country of origin, where you allege that you are persecuted. Now, what would happen if negative determination is made? So if negative determination is made at the refugee determination is made at the Refugee Protection Division, that's where you had your hearing. You can appeal at the Refugee Appeal Decision. It's also called the RAD. In short, we call it RAD. And after receiving the negative decision, you have to file a document called Notice of Appeal. And then in another 30 days, you have to submit the appeal record, which contains your affidavit and arguments for why you're appealing the decision at the hearing. There are 3 possible outcomes at the RAD. They might find that they might overturn the decision at RPD, meaning the division where you had your hearing. And they might say the lower tribunal was wrong. You are deemed to be a refugee. But more often, they uphold Refugee Protection Division's negative decision. And sometimes the case is sent back to the RPD for another hearing. This is often the case in the case of procedural fairness, where a certain element of the evidence was not considered. So in the case that you received another negative determination at RAD, which is the case in most instances, you can appeal at federal court or apply for humanitarian and compassionate application. What's important to remember is that you cannot apply the two of them at the same time. If you appeal at federal court, you again have to notify the federal court that you are appealing the negative decision within 15 days. At federal court, this is called a leave application, whereas at RAD, it was called notice of appeal, but it's the same thing as notice of appeal. Basically, we're letting the court know that we plan on appealing this decision. And within 30 days, application record must be filed. If everything is filed on time, the removal is stopped. So about the removal, when you apply to make a refugee claim, there is a conditional removal order, which basically states that your removal is stopped until you become permanent resident or while you are in the process. So while you are pursuing your appeal at federal court, removal is temporarily stopped. So there are possible outcomes at federal court. If the leave application is granted, that is basically saying, based on your written arguments, there are merits to hear your case. In that case, only your lawyer will go to federal court, not the clients this time. So your lawyer will be representing you, and a lawyer representing the immigration will be arguing against your lawyer, and the federal court judge will be hearing your case. In that case, there are, again, 3 possible outcomes. Either Refugee Appeal Division or Refugee Protection Division decision is overturned, and you are deemed to be a refugee, or Refugee Appeal Division negative decision is upheld, or the case is sent back to RPD or RAD for another determination. If the leave application is rejected, your case is not heard and the case is dismissed. So when I say leave application, it means just notice of appeal plus the written arguments that goes back and forth between lawyers. If leave application is successful, the case is heard. If not, the case is dismissed. So I said that upon negative decision, you can file either appeal the decision at a federal court or file humanitarian compassionate application. So I am going to go through the eligibility for humanitarian compassionate application. Basically, you are not eligible to make a humanitarian compassionate application if you received a negative decision from the RPD, Refugee Appeal Division, or federal court within the last 12 months. This is called the 1-year bar. However, the 1-year bar does not apply if you have children under 18 years old who would be adversely affected if you're removed from Canada, or if you have dependents who will suffer from, you or your dependent will suffer from a life-threatening medical condition that cannot be treated in your home country. That's considered a medical exemption. So I've tried to explain briefly on about the refugee claim process in Canada. I'm wondering if you guys have any questions.
Thank you, Christine, for this fruitful, informative presentation that gave us an idea about the process of refugee. I'm welcoming any questions here. However, I would like just to remind everyone that this session is being streamed on different social media platforms. So please try to avoid sharing any personal questions or personal details, anything related to your case. If your question is general related to the topic, please feel free to raise your virtual hand, mute yourself, and ask your question ahead.
So I see a question from one of the participants. It says, what would happen after the 1-year bar pass, after the humanitarian and compassionate request? I think, well, after the 1-year bar passes, you can obviously apply for humanitarian and compassionate application. I don't know if you mean by what would happen to your humanitarian. So after that 1-year bar, you can certainly apply for humanitarian compassionate application. Did I answer your question, AK?
I have
So
another question from Carlos.
So another question from Carlos, and another question, AK has a follow-up question. So AK, do you mean that, are you talking about humanitarian and compassionate application? Okay, so I will respond to AK and Carlos at the same time. It looks like you guys have questions on humanitarian and compassionate application.
Also, we have another question. Is it better to have hearing late or early?
Okay, I see that question. It's really, it depends on if you're ready, right? If you, we encourage clients to gather as much evidence as you can. And if your evidence is there, then we can train you for a hearing and you can go. But if you don't have a single piece of evidence, do I want you to go ahead and draw an earlier date? No, right? So there are 3 elements to a hearing. 3 elements to claim: the basis of claim form, the immigration forms, and number 2, evidence. Number 3, your oral testimony. So the first one, your lawyers will help you to build a strong claim. But as to the evidence, it's the client's responsibility to gather evidence. We can only make recommendations as to what kind of evidence to obtain, but it's the client's responsibility to ask friends, ask professionals, and to gather that evidence. If none of that is done, do I recommend that you go for an oral hearing? No. So, and your counsel should be in a good position to be advise you of that as well.
Thank you so much, Christine.
I see another question from another person. How long does this process normally take? So I see a lot of questions about the processing time. So it's important to remember that government does not have deadlines. Et Basile, je pense que tu parles français, donc je vais répondre en français. Il n'y a pas de date limite pour la procédure, le gouvernement veut prendre autant de temps qu'ils aimeraient. Mais normalement, je vois 1 an ou 2 ans pour l'attente. So someone asked, how long does the process take? I think they're referring to the processing time of the Refugee Protection Division. Again, the government does not have deadlines. There's very little predictability. On average, in most instances, we see 1 year. We see 1 year waiting time, but there are sometimes cases get transferred from another board, like Montreal. In that case, we see further processing time. Some cases are more complex, and it invites intervention from the minister. That usually takes more time. Sometimes files get lost. That usually delays. But on average, I see about 1 year. But it's based on case-by-case basis. So about some people wanting to know a bit about the humanitarian cases and the processing time. So what I can just let you know is what I can show you is what is required for humanitarian. Basically, humanitarian and compassionate looks at the following factors: how settled the person is in Canada, general family ties in Canada, general family ties in Canada, which is something that refugee claim does not look at. The best interest of any children involved, what would happen if the permanent resident is not granted, factors in your country of origin, includes but not limited to medical inadequacies, discrimination that does not amount to persecution, so social discrimination, whether it be because maybe because you're a single mother, you're a homosexual, you have mental illness, and other harassment and hardships that you've experienced in your country of origin. Again, health considerations, family violence considerations, and the country conditions, meaning the general condition of the country. And I have to say, from my experience, they also look at economic independence of the clients. So there are cases where people are not able to work, but at this point, the process for the second stage approval is that you have to show that you're not depending on the governmental support. So so I think I've answered the question about humanitarian and compassionate application. Humanitarian compassionate application, someone asked about the processing time. So again, this is a little bit tricky because it's just that there is no deadline for the government to issue a decision in a certain period of time. It's usually, right now I'm seeing around 2 years, but sometimes it is longer. It's just that your lawyers are not in charge of it, so we cannot tell you when you will get your decision. So I would say 2 to 3 years based on my experience, but it's not something I can guarantee. I see another question. So I am going to ask another question that says, I have a problem since I asked for shelter. I have not been able to have my work permit and my brown sheet paper expires this year. This is a very personal question. You can certainly email our office after after the presentation, and we can get back to you on that.
Thank you so much, Christine. So
yes.
if there is any other questions.
I see. I see.
Yeah, we can take another one. That's fine.
Okay.
There's a question from Martha, if I may. If you are working in healthcare, does that help with the hearing?
That's interesting. Okay, so technically, no. The refugee claim is supposed, so they're supposed to look only at what happened in your country of persecution. However, I see that more and more members ask about whether you're working in Canada, and they seem to grant positive weight to those that are working, although they're not really supposed to look at that. Does it help with healthcare? I'm going to say no, it's not supposed to help. But just working on its own, it may grant you further, you may get some extra credit, although you're not supposed to, from the member for working.
So at the end of this presentation, Christine, allow me to thank you so much. And if I may just also say that this is one presentation from two presentations. The other one will gonna be about the international students and the immigration system, which is a presentation that I'm expecting a lot of attention, taking into consideration the current immigration status of the international students. So at the end of this presentation, thank you so much, Christine, for your time and effort. I am so grateful as an RRAI Executive Director for all of those wonderful knowledge that you have shared today.
Thank you, Hetham.
Thank you so much. And for everyone, stay well, stay safe, and we are looking forward to see you at another session with Rights and Responsibilities Awareness Initiative.
I have a question.